Right, good afternoon. Welcome to everybody joining this webinar. It's always exciting to start one of these events, although we're quite experienced. It's also, I don't see you, you see us. So I'm hoping that you've had a nice lunch and are all settled in for an interesting ride, I think. What are we going to do during this webinar? We're going to discuss the European Commission's recast proposal for the Single Permit Directive, which was tabled on April 27, 22. And last spring, the European Parliament agreed on its position, as did the Council before summer, and now negotiations are ongoing. The webinar that you're attending is part of a series that is put together by a group of Horizon Europe funded consortia, research consortia, and all of us, we're looking into the rights of migrant workers, irregular or undocumented, or working with a single permit yet in a vulnerable position one way or another. And as part of these different projects, this series has been set up, and I hope that you join this one as well as following webinars that we'll organize. My name is Tesseltje de Lange. I'm a professor of European migration law at Radboud University in Nijmegen. I'm the PI of Dignity Firm, and I'm also coordinating a Dutch project on opportunities and barriers of labor migration to solve labor market shortages. And it is within these projects that we bring this webinar to you. Next slide, please. The Single Permit Directive, which I just mentioned being recasted, is interesting from a policy perspective, but also legally. It has administrative law, it is migration law, it is employment law. It's a mix of many different legal fields, policy fields, and thus also of all sorts of different interests that are engaged and people engaged in discussing this recast and arguing for certain changes or against them. And it is that discussion that we want to bring to you. Next slide, please. We're going to start with Clemence Ghighi. She's a policy officer at the European Commission, DG Home, on Migration and Home Affairs. And she will be sharing with us the first introduction of the recast and the position of the Commission. Having said that, Clemence, I want to give the floor to you. Please open your camera and microphone, and the floor will be yours.
Thank you very much, and thank you for inviting us today for this interesting webinar to speak about the recast proposed by the Commission of the Single Permit Directive. So I have shared some slides.
Yes, thank you. You have they're in the PDF format. So this was a small technical thing. So that's a question for the technical team to have the PDF slides from Clemence shared on the screen. We'll be there in a second, I'm sure. Is it true, Clemence? I hear it's quite a heated debate still that's ongoing, right? On the recast, but that some articles have at least already been agreed on. Am I right?
Yes, exactly. I mean, the negotiations are ongoing since June. We hope that, but I will also cover this in my presentation, but we hope to reach an agreement as soon as possible. There are a lot of discussions. As you may know, the whole pact on migration is a big discussion. So yeah, it's advancing. So we hope to get the recast adopted relatively soon.
Yeah, well, I think many of us might share that hope. of course, also with elections coming up next year. Speaking from Dutch experience, you never know what happens at elections. Of course, it would be good to finalize some of the initiatives that are out there. In the meantime, I think the technical team is having a little bit of a trouble uploading the PDF. Maybe they can update us briefly on what's happening and if we need to do anything. Otherwise, we just wait for another second. Apologies then. I think Jill is the one who is in charge of sharing the PDF. And or if Sterra can, maybe that's also an option. Yes. Here we go. Okay, Clemence, sorry for the delay. The floor is yours. And if we need to proceed, just say next slide and somebody will hit a button.
Thank you, thank you. So as I started earlier, I will give a presentation of the Commission proposal for the recast of the Single Permit Directive. I will also go a little bit in the history of the directive to explain why the Commission proposed a recast, and I will also end with some information on the ongoing negotiations. Next slide, please. So to start with a bit of context, as you know, the Single Permit Directive was adopted in 2011 and is implemented since 2013. It was an important step because it's the first EU legal migration legislation that combines both the authorization to work and reside in one single permit and one single procedure. It's also very important because it lays down the rights of the third country workers, especially with regard to equal treatment. So following the adoption and the transposition by member states of the directive, the Commission adopted in 2019 what we call a fitness check on all the EU legislation on legal migration, together with an implementation report on the Single Permit Directive that looked specifically at how member states transposed the directive in their national law. So these two documents showed some of the limitations of the directive, especially with regard to the single procedure that must be applicable. So the delays or the different steps in the procedure could create hurdles for third country nationals, but also the need to increase the protection of third country workers, especially against labor exploitation. So against this background, in 2020, the Commission adopted the new Pact on Migration and Asylum in the EU. This is basically the roadmap of the Commission on the migration policy. And in this new pact, the Commission announced the recast of the Single Permit Directive, but also of the Long-Term Residence Directive as part of a broader policy on legal migration in order to improve the legal migration procedures. Following that, in 2021, the Commission undertook an impact assessment where we have analyzed the different challenges in the current directive, how they could be addressed, and what would be the best way to address them. which led us to adopt in 2022 the Skills and Talent Package, which includes various initiatives, including the directive, the recast of the Single Permit Directive. Next slide, please. So just to give a very short introduction of what is the Skills and Talent Package, it's basically the new policy of the Commission in order to improve the attractiveness of the EU for third country workers and third country talents. So it includes 3 pillars: one legislative, including the recast of the Single Permit Directive, but also of the Long-Term Residence Directive; an operational pillar with what we call talent partnerships. It's to increase the cooperation with third countries on mobility. The EU talent pool, for which the legislative proposal was adopted actually just a couple of weeks ago, which is meant to create a pool to improve the match between employers looking for workers and third country nationals looking for work. And the Libre migration platform, which is a place where both authorities from the migration side and the employment side meet in order to discuss labor migration. And there is also a forward-looking pillar looking at different areas of action, including care, youth, and innovation. Next slide. So now, if we focus on the recast proposal of the Single Permit Directive presented by the Commission, it actually follows 3 main objectives. The first one is to simplify and streamline the single application procedure in order to make it faster, but also easier for third country nationals to make a request and be granted a single permit. It's also to increase the protection of third country nationals against labor exploitation, but also to clarify some of the equal treatment provisions where we saw there were some deficiencies. So the first main objective, that, as I mentioned, is simplifying and streamlining the single application procedure. Here, the main changes proposed by the Commission is to allow that applications for single permits can be lodged both from a third country, but also from the member state if the person is legally present in the member state. But it's also to kind of reinforce this idea of having a one single application procedure and create what we call a one single time limit. And here, basically, what the Commission proposed is to include in the 4 months processing times already provided in the directive to review the application for a single permit, to also include in these 4 months both the issuance of the entry visa, because as you know, in many member states, residence permits are not issued abroad, so the person should have a visa to enter and then be formally granted the residence permit, but also to include in these 4 months the time needed to conduct the labor market tests. Here, these 2 steps were included in the processing times because our impact assessment showed that some delays could come from these steps, and we're creating actually additional time needed in order to have the procedure completed. And in order to simplify and streamline the procedure, the Commission also proposed to introduce a right to change employer during the validity of the permit in the Single Permit Directive. So here, I will also explain in my next slide, but here it's the idea is that it simplifies the procedure because on the basis of your single permit, you will be able to change job and employer without asking for a new permit from the beginning. That's the idea. Next slide, please. So as I was mentioning also earlier, the second important objective of the recast is to strengthen the protection of third country workers against exploitation. So here I already mentioned the right to change employer as a way to simplify the procedure, but it's also a very important tool in order to strengthen the protection of third country workers, because it will detach the employment from the permit. What do we mean here is that in some countries, the third country worker has a permit in which it's specifically specified for which employment, so for which job he can use this, he or she can use this permit, which of course can create a link of dependence. And in case of issues linked to exploitation or abuses, it puts third country workers in a very vulnerable place. So the idea here is to allow also this change of employers, so that the person, in case facing these difficult situations, can change employer easily and break the link of dependency. In order to strengthen the protection of third country workers, the Commission also proposed to include a minimum period of 3 months, during which if a single permit holder is unemployed, the member state will not be able to withdraw the permit. So that's a minimum period. Member states can go beyond if they wish so. And it's also aiming at breaking the situation of dependence. And in case the person did not find another job, the person could leave his or her job and stay on the basis of the same permit for at least 3 months. Of course, this provision also helps the procedure and to address labor shortages, because it creates a better circular migration and use of the people inside the territory without them going back and forth to the third countries. And also to increase the protection of third country workers, the recast proposed to include also complaints, labor inspections, monitoring, and penalties mechanism in order to address the situations where employers may abuse the rights of third country workers. This mechanism is similar to what we have in the seasonal workers directive. Next slide, please. Next slide. Sorry, there is just one. Exactly. The third main objective of the recast is also to clarify the equal treatment rights. So here, the recast is really looking at targeted amendments in order first to extend the scope to certain categories who are not covered by any EU legislation at the moment. This includes beneficiaries of protection under national law. The recast also clarifies equal treatment by explaining that if member states limit the access to housing, it should not be limited to private housing. So third country workers should always have equal access to private housing. And the recast also provides that when it comes to family benefits, third country workers working on the basis of a visa should be treated in the same way than those working on the basis of a single permit or residence permit. Next slide, please. So here are the main objectives and changes proposed by the recast. There are others, but these are really the main important changes. And since the adoption of the proposal by the Commission, as already explained before, the European Parliament adopted their mandate in April 2023, the Council in June 2023, and the trilogues between the three institutions, so the European Parliament, the Council, and the Commission, started in June 2023 in order to find a compromise on this text as soon as possible, and we hope very much before the end of this legislature. Thank you.
Thank you very much, Clemence, for a very clear and overview. something you said triggered me. So I'm really happy that how the Commission also stresses the relevance of equal treatment and protecting migrant workers' rights and detaching employment and the residence permit as much as possible. But you said one thing. You said it's also sort of intended to make better use of people present in the EU, so that they can find work across the EU. But has it been part of the drafting process to think of some sort of intra-EU mobility? Because that's, of course, the most equal treatment to EU citizens that we could offer them.
That's indeed a very interesting question. I mean, so in the Single Permit Directive, it's true that intra-EU mobility is not tackled like it is, for example, in the Blue Card Directive or the Students and Researchers Directive or the Long-Term Residence Directive. The main difference of this directive is that it's mainly procedural, so it doesn't really go into the admission conditions and all the little specificities of the permit, and in this context, intra-EU mobility is not addressed. What I meant earlier when I said that the right to change employer or the possibility to stay unemployed for 3 months was also aiming at facilitating the hiring of third country nationals in the EU. I meant that via these kind of procedures, people can actually move within the labor market more easily, both for them to find another job, but also for employers to find the people they need. And even if intra-EU mobility is not provided there, the fact of having such procedure in the single permit would be already quite an improvement at EU level, as it would create a kind of harmonization on what are the rights of third country workers in all the EU.
Yeah, clear. Maybe it's good to let our audience know that if people have questions, either for Clemence or the other speakers, please feel free to use the Q&A and drop your question there, and we will moderate it, and we will get back to the questions and the final minutes of the webinar, or after the webinar if we don't find the time to address them during this 1 hour. Clemence will be with us for the remaining hour, so indeed, if there's questions to her, drop them in the Q&A, and we'll get back to that. And now, Clemence, if you'll allow me, without further ado, I'm going to our next speaker, which is Amy Weatherburn. And Amy is a postdoctoral fellow at the University in Brussels, and you've done a report, quite impressive, on the lived experience of migrants in the EU holding a single permit. And you've looked at what it is for them, what it's like for them to have one or to lose one and to get one back again. It was a joy to read, and we're really happy to have you here to tell us about your research findings. Amy, please, the floor is yours.
Thank you very much for the introduction, and also thank you to you and the organisers for the invitation to present the findings of this study. Next slide, please. It's very fast. So I'm going to discuss the findings of the study commissioned by PICUM and conducted under the auspices of the ULB Equality Law Clinic, that indeed, as you've just mentioned, documented the lived experiences of prospective, current and former single permit holders. The study has a comparative element between 3 EU member states, which was made possible by the collaboration with PICUM members in Belgium, the Czech Republic and Spain. Next slide, please. Before I go into detail on some of the key issues that arose in the 31 interviews that we conducted with migrant workers, I want to briefly outline the lived experience of a Nigerian business graduate who came to the Czech Republic to work in academia as a research assistant. He then got a job in industry as a business analyst, and after 2 years was told that he either had to, by his employer that he either had to relocate to the Philippines or he would lose his job. He, in fact, decided to stay in Prague and as a result quit his job. And one of the problems that he came across when he was seeking alternative employment was that for employers who were potentially offering him a job that would match his skill sets, they actually were then discovered that they would be unable or unwilling to accompany him with the application process for a single permit. And because his unemployment status meant that his resident status in the Czech Republic was at risk, it meant that he was actually required to apply for jobs for which he was vastly overqualified. And overall, in his experience as well, he relied on his employers to renew his permit, and as a result of this dependency, felt strongly obliged to work overtime, to take on additional tasks, and he really had this sense that there was an unequal playing field when it came to the position of power that the employers had over him, and the way that they exerted this over the migrant workers in their workforce. And this was in part, again, related to the fact that there was a dependency not only for their job, when that had a link to their resident status, but also the idea that they would need the employer to renew the permit. So this situation really brings to the fore some of the key issues that I want to discuss today. And whilst the study itself identified many more issues of concern, in the limited time I have, I want to place an emphasis on 3 key overlapping issues: the ability to obtain and retain a single permit, the role of the employer, and the right of single permit holders to change employer or to seek alternative employment where they lose their jobs. Next slide, please. So first of all, when it comes to the application and the renewal procedure, both of these were particularly problematic, as overall they were lengthy, costly, and complicated for both prospective single permit holders and the employers alike. The application procedure lacked transparency, and this was something that we discovered in all 3 countries. And single permit holders who were interviewed often referred to the frustration in not receiving any updates or any info in relation to the status of their application. And similarly with the renewal process, an issue that arose here was that because of the lengthy procedures, the process had to begin well in advance. However, many single permit holders had very short-term employment contracts, which often meant that their job security couldn't always be guaranteed by their employer. And in this sense, the employers were not always able to guarantee that they would extend their contract, and therefore this had implications on the renewal process. And this left single permit holders in a period of uncertainty and potentially in legal limbo. Similarly, when it comes to applications or renewals that were rejected, in some circumstances, we came across reasons or grounds for rejection that actually didn't have a direct effect or a direct link to the applicant or the single permit holder, but rather the actions or the conduct of their employer. For example, where employers didn't register workers with the national labour authorities, this would be a reason for rejecting the renewal of an application, for example. And finally, when it came to rejections, the appeals process also was considered to be extremely lengthy and lacked significant certainty, and because of their complex nature, required legal assistance, either from internal legal services provided by the employer, or the single permit holders would have to seek legal assistance elsewhere. And similarly, in this regard, the lack of a formal appeal process is something that has led to this uncertainty, and is something that we certainly noted in the Belgian context. Next slide, please. So the difficulties encountered when obtaining and retaining the permit meant that employers had a very prominent role in the experiences of the single permit holders when they were in Europe. And in particular, this is because both the application and renewal procedures are employer-led. And this can be problematic when there is either a lack of willingness or limited experience on the part of the employer to go through with the application procedure. And as I've already mentioned above, an application could have been refused due to the fraudulent practices of the employer, which in turn can then lead to a significant impact on the single permit holders because they then lose their regular migration status. And an example of this is in the Czech Republic, where, for example, if an employer was deemed to be unreliable by the authorities, this is a ground for refusal in the Czech context. But of course, the result of this refusal would mean that the single permit would not be renewed or granted to the individual who was asking for it. And so overall, the dependence and the exercise of control that the single permit holders had, the employers had over the single permit holders could potentially lead to exploitative working conditions. And in the study, we heard of examples of underpayment of salaries, employers requesting or rather deducting additional payments for example, fraudulent tax contributions, so-called tax contributions, or for the need to pay health insurance when in fact it was the obligation of the employer to pay the health insurance. And we also came across bogus self-employment arrangements. Next slide, please. So the final thing I want to discuss is something we've already heard about, the right to seek alternative employment. And this is something which is important due to the fact that the dependency on the employer was heightened by the limited opportunities for single permit holders to change their job. And crucially, we do need to note, however, that there is a diversity in experiences because of different conditions in national law and policy. Very briefly, in Belgium, there is a restricted approach. So a single permit holder will have 3 months to not only find a new employer, but also to apply for a new single permit. And we know that the procedures themselves take longer than 3 months, so this is an unrealistic expectation. In the Czech Republic, there are conditions. You must work a minimum of 6 months for your initial employer, and then you have the right to 60 days unemployment, and you can change to a new employer as long as you notify the authorities and keep the same single permit. And in Spain, there are no restrictions. You can change employer to any sector and any job during the validity of your visa. However, here we did come across problems where, for example, other aspects like the lack of available housing or accommodation meant that people couldn't actually take up job opportunities elsewhere. And so overall, the combination of the right to reside and being contingent on the right to work is problematic, as we saw examples of a lowering of human capital and a skills mismatch, employers then taking advantage of this access to overqualified migrant workforce, and a lack of equal treatment in the workplace. And as I gave in the example at the beginning, an acceptance of potentially poorer working conditions. Next slide, please. So just to conclude then, overall, the study identified 8 key areas of improvement. And today, given the focus on the recast directive, I see my contribution being towards those that have the lived experiences, where the lived experiences of single permit holders can be co-opted into meaningful legal reform. So I would like to present 3 recommendations. The first being that application and renewal procedures must be simplified and made more accessible, with, in addition, the duration of the permits granted reflecting the reality of procedural delays and the procedural mechanisms that states put into place. Second, the dependence on the employer must be reduced, which in turn will minimize the risk of exploitation. And finally, the ability to change employer must be facilitated with a view to ensuring a correct valorization of the social and human capital that these third country national migrant workers contribute to the EU labour market. Thank you very much for your attention, and I look forward to any questions.
Thank you very much, Amy. Amazing research, very important findings, I think. And I also like it very much that you actually used clinical teaching as a method, so that you actually engaged your students in the research, which I think is also a very important aspect of our work in academia. As said, there is an option to raise questions. I saw some questions coming in already. Please use the Q&A button instead of the chat button. And I don't see any questions specifically to Amy right now, maybe on clarification. So I suggest we, Amy, if you'll allow us, we'll go on to Lilana at this stage. And Lilana Keith is a senior advocacy officer at PICUM. And she's also our partner in our Horizon Dignity firm, and she's joining in the other Horizon project, at least in Miriam as well. So it's good to have you here, Lilana. Thank you for joining us. And we've asked you to, of course, you know Amy's work, you know the proposal. You've done a lot of advocacy on specific topics that are addressed in the recast and at the table during the negotiations. Actually, that's also one of the questions that I saw in the chat was what are the most touchy topics during the negotiations. And I'd really just like to give you the floor to explain your position as PICUM on this directive and what you think should and hope will improve. And we don't have slides, so we will just enjoy your talk. Go ahead, Lilana.
Thanks, Tesselje. Thanks to all the organizers for inviting us. For those who don't know PICUM, we're a network of about 160 member organizations in 30 countries, mostly in the European Union. All our members are working with migrants with different kinds of statuses. Many of them are undocumented. We exist really to defend the human rights and social justice for undocumented people. But in the case of migrant workers and labor rights, we take a bit more of a comprehensive approach because we really see the need to look structurally at labor rights violations, at labor migration, why people are working in precarious situations even when they have a permit, and why people are becoming undocumented, how we can get them out of that status. So for us, the Single Permit Directive has been a really important piece of legislation. We really welcome the Commission proposal, everything that was put on the table, the objectives that Clemence has already outlined. It was a step for us in the right direction on a number of key points that we had seen from the experience of our members were really important to improve the work permit system across the region. We also saw a lot of areas where the Commission proposal could be improved. And indeed, the European Parliament, we've had the pleasure of working also with the European Parliament, with the rapporteurs from the Socialists, with also Tineke's team, who will speak afterwards, to try and see what the Parliament could do in their position to also bring those experiences of migrant workers in and improve on the Commission proposal even further. I can't comment on the actual negotiations as we're not part of the negotiations. Hopefully Clemence or Tineke can do that. But what I can comment on is really what for us have been the major priorities in our side of working with the Commission and the Parliament on this file. And obviously with member states as well. Through our members, we've been trying to talk to the national governments and to the Spanish presidency. So our priorities have been change of employer, job and sector, and addressing this loss of status that Amy and Clemence have already touched upon. Certain aspects of the procedure, processing time, but also in particular around the lead applicant. Amy was talking about the dependence on employers for applications. So we were trying to look at how to also reduce that dependency and give more ownership and autonomy to workers in the procedures themselves. As well as looking at in-country applications and broadening that scope and use, trying to see whether the directive could also strengthen the provisions around access to information for workers as really being a key way to facilitate for them, to empower them to enforce their rights. Look looking at the specific supports and complaints mechanisms that would be in place in case of labour rights violations. I just saw a flash that my connection is unstable. Do you hear me okay?
You're back. You were off for a second, but please continue.
Okay, great. So I wanted to focus now on the right to change employer and employment, because that to us is the biggest game changer that has been put on the table in this negotiation in the recast, that would have the biggest impact on actually improving the rights of migrant workers across the region. And for those who maybe are less familiar with the directive, there's nothing on this in the current directive, but it is somehow, it's not a problem that was created by the directive. It existed to some extent, but the fact of the very useful objective of the Single Permit Directive, combining residence and work permits to simplify procedures, actually cemented and made worse this dependency of somebody for their work permit on an employment, but also for their resident status on employment. So this link of a migrant worker having to rely on their one employer for everything has been in a way worsened through the implementation of this directive, even if it was in no way the intention or foreseen in how that would play out, and was not created by it. It was pre-existing but worsened. So we really saw that it was necessary, and we're really, really pleased that the Commission did put this on the table, tried to rectify the situation to a certain extent. For us, the key things that you have to recognize is what is the procedure for a worker to change employer. It's one thing to say, okay, you need to be able to change employer, but what does that look like? And it has to be substantially, significantly different from a new application. Because what we see is that in several member states, workers have to do a whole new application procedure. The only difference would be that perhaps they can make that application from within the country. But that is not, it doesn't give enough predictability or security to the worker to actually know that they will be able to maintain their status in the country. And so in reality, it's completely unrealistic and people feel like it's impossible to change. So we need a procedure which is predictable, it's free, and it's quick, so that it can actually really be meaningful, both for the worker and for also the prospective employer. The state, you must also have a decent period of time, Amy mentioned this, to actually seek an alternative employment. Because if you're in employment, we all know how difficult it is to find another job and how long that can actually take. So we've seen from practice and from evidence also from Amy's study that 3 months, as it is in Belgium, which goes beyond the validity of the permit. So this is actually more than what the Commission put in the proposal, which is 3 months within the validity. It's not enough. So we've been really trying to push as well for that period of time to be much longer and to be beyond the validity of the permit, regardless of the period that it is. Because if this would be to happen right at the end of your permit, then you wouldn't be able to change employer and you'd be in that situation. We've seen the council position has been very much to try and maintain the status quo in enabling all the countries to continue exactly what they're doing now. They have put in their position that they would like to have the option to have no procedure, as some countries have now, and is what we actually advocate for, that you can change employer freely within the validity of your permit. They say you should be allowed to have a notification procedure, as many other countries have, and that you should also be allowed to have a new application. And we've seen that that is not, it's just not feasible. It's not an option for us to maintain that. But we're also worried that the procedure, if it would be called another thing, like a notification procedure, that it would not somehow turn into a application procedure by another name. And that's why I'd also like to underline for us, we have a big concern with the revision of this directive and this particular issue, is that maintaining the status quo, but enshrining that in EU minimum standards actually risks for us to worsen the situation, because it would kind of normalize the idea that you have a right to change employer when it's not actually a right, and you can't actually exercise that right. And then that's in as minimum standards in the EU. So in our work on national level for the next 10, 20 years, we're going to be stuck referring to this being in line with the EU law. And there's also this proposal from the council to actually include a minimum time period where the worker would have to stay with the first employer, which is exactly the opposite of a right to change employer, and actually very, very rare in the EU. So we're extremely concerned to see that that would actually be put in as an option for member states going forward, especially when we look at the political situation and how having that in EU law could actually enable others to, I mean, they have the right to do it anyway, but kind of give the green light to say, you know, this is okay in terms of minimum standards for us to put in these kinds of regressive and repressive measures that we found to be harmful in other EU member states. So that's really kind of the most important issue that we see on the table in the negotiations now. We've also very much been lobbying around the other issues, and maybe just to mention very briefly, because I know that we have to go to other speakers, but additional protections as well for those who actually experience labour rights violations, like an extension of the permit for a longer time or a transitional permit would actually be crucial, and we're hoping that the negotiations will still bear fruit on these points. Thanks very much.
Thank you very much, Lilana. I think you raised some very interesting and valid points. I also see that in the chat, for instance, Nora Gottlieb asks how what is happening at the EU level relates to, for instance, the kafala system in the Gulf states, which also ties a worker to a very specific employer and has them stay with that employer. Is that one of the arguments, Lilana, maybe really shortly, that you've, or is that information that you build your arguments on?
We definitely see a lot of similarities between the EU system, not the EU system because there's no EU system, but in many EU member states and the Middle Eastern states, there's a lot more similarities than you would expect. Okay,
well, thank you very much. That's then not the most cheerful comment maybe to end with, but as you're in the Department of Advocacy, there's plenty of work to be done. I would like to switch to our last speaker, which is Tineke Strik. And Tineke is, for me, first of all, my colleague, a professor here at Radboud University. She's a professor in citizenship and migration law. She's also a colleague in the GAPS project, co-organizing these webinars, and she's a member of the European Parliament at the Libre committee, and as such involved in the negotiations of the single permit. And that is why we have you here, Tineke. And as one of the questions was raised, what is the state of play in negotiations? Maybe what are the most touchy topics that still need to be dealt with at this stage?
Yes, thank you, Tesseltje, and thanks also for being the last speaker, because I can also refer to many of the things that have been already mentioned, because the most contentious issues are already mentioned. I think it's the scope, it's the length of the procedure, it's definitely the change of employer, and also the length of the period of stay after unemployment, and also to a certain extent equal treatment elements. Shall I go through them where we stand now, Tesseltje?
Yes, I think the audience would like that. Thank you.
On the scope, I mean, the Parliament really wanted to include many more categories, which are now excluded, also to avoid fragmentation and to give everyone the same type of protection. The Council is very reluctant in expanding the scope. And what is now on the table is exclusion from the full scope, but apply Chapter 3, so the rights to beneficiaries of national protection in accordance with national law, if they are allowed to work in their country, in the member state. And a new provision that those categories who are excluded are still allowed to change status to a category that is included. Actually, to be honest, that provision doesn't do a lot, because this is always possible. So yeah, I'm not so convinced about this compromise proposal by the European Parliament, but still it was rejected by the Council, even that it was not meaningful at all. They want to, they are ready to look for this Chapter 3 application, but they don't want to have this second. And I think that therefore I would really hope that that's also a new avenue for us to come back on trying to include more categories, especially, for instance, beneficiaries of temporary protection directive would be at least good. The decision-making time, we wanted to restrict it to have more alignment with the Blue Card Directive and the seasonal workers. We wanted to have 90 days and with no extension possibility, and also including the visa procedure. The Council wanted to keep 4 months, and then in addition to that, the visa procedure. So we are now talking about 90 days, but then outside, excluding the visa procedure, and no extra extension. So that's it. And the Council wants to have 90 days, possibility of extension, and the visa outside of this period. And we...
Labor market test would be included in that 90 days?
Yes, also. And so it could be the case that because we want to restrict the extension for cases that are really more complicated, and for the maximum of 30 days, so that, you know, a labor market test would be a justification if that would be complicated check, for instance. But yeah, the Council now wants to have 90 days visa and the extension to 30 days. So actually what I have now proposed now also to at least if we find a compromise there, that we could also include what is now also written in Article 13 of the Family Unification Directive, which says that as soon as the application has been accepted, states must authorize the entry immediately, something like that, because a visa procedure can also take a long time. But we're not there yet. We're still, you know, having the position of 90 days with a possible extension of 30 days if really necessary. The change of employer. This is indeed a very hot topic. What we wanted is to have the possibility to immediately change employer, and to only have the possibility of a labor market check if it means changing sector, but not change employer within the sector. And we wanted to have indeed a notification procedure, but a real notification only, and the possibility of the employer or of the state to only object within 30 days. Because if you do that longer, it will be a huge hurdle, I think, for employers to take someone into, because you don't know if it will be challenged by the state. This is changed, yeah, and the Council, they wanted to have the first 12 months that people have to stay with the first employer, and if they change, always a labor market test, and also the possibility for a member state to challenge, to object, I think for 90 days. Yeah, for 90 days. So 3 months time for a member state to challenge, which is making it hardly doable anymore and feasible for an employee to get the job. So we are now looking at possibility to get, our proposal was actually, as our compromise proposal was to say, okay, then let's make a change that the first 12 months that someone wants to change employer, that a labor market test is allowed. And after 12 months, only a labor market test if there's a change of sector. This is not acceptable, I believe, for the council. Still, they want to keep a period for first employer, and now they propose to us, let's change this from 12 months to 10 months. But that's still undermining the whole idea, you know, also what Liliana was saying, that it's so important not to keep an employee, imprisoned actually in a contract with an employer who abuses the person. So I really hope we're not going into that direction. And there is another thing. Oh yeah, there's also another thing about abuse. The council did not really have something specifically to protect people in abusive situations. And we said that we wanted, after unemployment, that we wanted to give 9 months of permit in order to find a new job, and 12 months in case of serious violations by an employer. This was also not acceptable. So what we now have proposed is if a SPD holder had a permit shorter than 2 years, there should be an unemployment period for 3 months. After 2 years, it should be 6 months. And in case of violations, it should be 9 months. So then we should have an additional 3 months. The council is not yet that far to accept that. It said it challenged it with 2 counter proposals. One is that if that the additional 3 months after 2 years, so in case of 6 months, that the last 3 months there should be an income requirement, so people should have an independent source of income, and they would only be prepared to talk about this additional 3 months in cases of abuse if we would agree with the first 10 months first employer.
That's negotiations. Clearly.
That is what you call negotiations indeed, and sometimes it really brings you a very awkward and difficult situations. I think that's the most important one element to mention is equal treatment. Yeah. That we really want to keep in the back payments that also the Commission proposed, and we wanted to have freedom of choice regarding housing, and the Council tries to limit that, to restrict this equal treatment for housing, and so there we really want to have to realize that there's no discrimination on the housing market, be it public or private housing. And the last thing is the definition of employer or employee. The Council did not want to have, there's no definition now of employer. Well, the question for us, it's really important because we want to make sure that it's not too easy to, with some kind of construction, to avoid any accountability or falling under the scope of this directive, because you say, no, but there's no employer-employee relation.
Thank you very much, Tineke. I think especially what you just said in the light of equal treatment, we haven't touched on that, and I'm definitely sure that we will in other settings and publications, etc. But of course, what you mentioned about the length of unemployment and the length to look for a job, the Blue Card Directive has just come into force this month, and it has its own schedule for that, and you'd think copy paste it into all the directives and treat migrants equally in that respect, even if it's not equal treatment to nationals, which you can even contest that that should be the case. So thank you very much for bringing all of this to the table. Dear audience, as you see, an hour is really short. Now, we've had some interesting comments and questions some for clarification, and some more content-wise. I want to suggest that we share the video, the slides, and a brief note in which we comment on the questions. I just wanted to do two things before we close. One is just briefly ask Clemence if indeed the question on the topics that are the core topics to the negotiations, as Tineke portrayed, if you agree or if you want to add on that. I do want to use the opportunity to give you that the floor to do so, and then I'll close. Clemence.
Thank you very much. No, indeed, I think the main topics are the same as explained by Tineke. So it's the scope, the time limits, the Article 11 altogether, so the change of employer and the period of unemployment, and equal treatment, which are of course where the main changes of the recast were. So that's indeed where discussions are more lengthy than on other topics, because they are more important as well, of course.
Yeah, thank you. I think that the question on where the partnerships come in, we will answer after the webinar. I want to thank all the speakers for your thoughts, knowledge, and contribution today, and also in the ongoing process and in ongoing research. Anybody who has further questions to this team, please feel free to reach out. And I have already good news on our series, is that our third series will be on February 5th, the next year, and it is organized by Soner Bartoma from the GAPS project, which is also Tineke's project. And it will be actually on EU partnerships and cooperation models on return and readmission. But maybe we can come back and combine some thoughts that were left over for today for the next webinar. And that is actually what we try to do, is we try to combine the knowledge that our consortias bring together and bring it to you. So I hope you enjoyed it, and that we've been able to create some insights on an ongoing negotiating process. Thank you very much.
Thank you. Goodbye.
Bye.
Thank you. Bye.
Thank you. Bye-bye.